Hi, welcome to Waterstone Legal Update, and I have with me Damien Grant, Principal of Waterstone, and my name's Adam Botterill, and we're going to be discussing a really interesting case that we've been involved in relation to liquidation and receivership. So, Damien, why don't you give us a background to this Decmil case, and why it's important, do you think, in terms of the current insolvency landscape?
We are liquidators of a company called Stanley Construction Auckland, and Stanley Construction Auckland is a retention creditor inside Decmil, or at least we claim that we are. The liquidator of Decmil disagrees, which is fine. So Decmil is a large Australian corporate and a very successful Australian construction entity, and they had a subsidiary in New Zealand called Decmil Construction NZ Limited. That got into some trouble with the Department of Corrections and I think the Ministry of Education, and they went into liquidation. At the time, or immediately prior, they went, because this was a construction company, and so under New Zealand law, construction companies must hold retention money in trust. And as the evidence emerged, Decmil Australia was accounting for the retention funds that they had in New Zealand in their joint treasury system. And so they made the decision to put Decmil New Zealand into liquidation. And then immediately prior, or within a couple of weeks prior, they transferred around $3.2 million from Decmil Australia into Decmil New Zealand to make sure that Decmil New Zealand was compliant with our laws. And the evidence that came out subsequently is that Decmil Australia was saying that they had always accounted for that, and that's correct and fine. The problem then emerged when the liquidator, Perth-based liquidator Dermott McVeigh, made the decision that the money that he was sitting on, that $3.2 million, wasn't necessarily retention funds, it was money that was available for the general pool of creditors. He then made an application to court to seek clarity on that and get directions from the court.
I think the application that was made, he positively asserted that the $3 million was general pool money and not retention. So that was the first application, and that was quite surprising. And a lot of the retention creditors disagreed because they were the ones that were going to miss out. Because if it was general pool money, essentially their claims would get washed into the larger pool of creditors, and essentially their distribution in terms of retentions wouldn't be available. So there was a lot of concern from that group about this application, about the decision. And there was,
now it was around that point that ourselves, Stanley Construction Auckland Limited, and a number of other creditors, but most prominently VAE, which is an Australian company that had retention funds as well, and a group of us got together, I think there was about 14 retention creditors, got together and we formed a fighting fund to challenge this. And also Decmil Australia had an interest in this as well, because they obviously believed that the money that they had put in was retention money. And it was important for the directors of Decmil, because if McVeigh was correct and that $3.2 million was not retention funds, then that was potentially an issue for the directors of Decmil Construction New Zealand, because they may well have been in breach of their statutory obligations
to hold the funds. And I guess we just glossed over pretty quickly the actually putting together of this group of retention creditors, but I think it's a really unique and critical feature of this, because without that group and having some money put together to actually hire lawyers to oppose the liquidator's application, this may not have happened at all. So I think we just got to talk quickly around that, because I think that was
quite impressive. And to be fair, a lot of that was your work, Adam. So we went to all of the retention creditors, and it was over half by dollar value, not quite half by number, I think, agreed to chip in some money. And then we went and we got advice.
We had to set up essentially like a document between us all, and everyone signed it, and it said we'll tip in 10% of our retention balance to create a fund by which we can go and hire lawyers. And Stanley Auckland and VAE were essentially representative creditors.
Yes,
so everyone nominated us as the two representative creditors. Then that meant that every company didn't have to be involved, but they were sitting in behind us. And I think that was really important from a streamlining perspective. So it meant we didn't have to go and get every micro decision past 14 people. Essentially everyone elected elected VA and Stanley
it was a mini class action.
A mini class action, I think, is probably a really good way to put it, and I think it worked well in the situation.
Yeah, we were pretty pleased with that. Now that case settled, so and some of the aspects of that settlement were covered by some confidentiality clause. So we won't go into it too much, but nonetheless, the case was settled.
We can say what happened in the round, and that was that McVeigh agreed that the money, that the $3.2 million was actually a retention fund.
Yep, he did.
And then the live issue that remained from that was just who was going to now manage this retention fund, and McVeigh wanted it to be him, and our group of retention creditors had a different view.
Yep. So there is a couple of alternatives put up, but I think it's our preference was Gareth Hall and Clive Bush from Eagers KTA, and so we went to the High Court, and we're represented by Wynne Williams and Mike Colson. It's Mike Colson QC now. We made the argument that looking at McVeigh's behaviour meant that he shouldn't be the receiver of the retention fund. So let's a little bit of context about that. So the liquidator was the agent for the company, but then we have a trust fund established. Now, we've seen a couple of other cases where this has cropped up. In the EBIT case, we had PwC I believe they were the general receivers.
They were.
They went to court and they got permission to be the receiver of the retention fund
As well.
Orshot in Christchurch had a similar issue with Bell.
He was a liquidator.
He was a liquidator.
He was given permission to manage
the retention
fund.
He was a receiver of the retention fund.
There was something that cropped up earlier in the case management was that Associate Judge Bell, as he was sitting then, his view was that, well, the liquidator could just be the trustee and actually distribute the fund. That never got argued in the end in terms of the full hearing of that. But initially he thought, well, the liquidator as agent of the company could wear the hat as trustee and manage it with potentially court oversight. And that was I think probably a clever analysis of it at the time.
Well, certainly I must admit that would kind of be my view. If I was a liquidator of a company that actually had retentions, I would be unsure as to why you would need to have a receiver.
Well,
of retentions.
The problem procedurally with how this played out was that that's not what McVeigh asked for. He asked to be appointed as a receiver of the fund. He wasn't asking for general power as a trustee to administer it. His application was to be a receiver. So you
allow him to take fees as well.
Correct. So you have Bell, and he sat there and was saying, oh, well, we should think about another option, but no one was asking for it, and even we weren't asking for that as well. We were wanting a separate receiver, not McVeigh.
And it's kind of interesting, because I don't know that Parliament necessarily ever considered the issue of receivers over retentions. It seems to be something that has happened organically within inside the industry, and I think because of these three precedents now, if you have a situation where there is a construction company with a retention fund, you're going to need to make that application, although the law is changing and we'll come to that at the end. But the argument that was made in this particular case, now because in the EBIT situation, the Corbell situation, the application was not contentious and it wasn't opposed.
No.
And so both of those cases, it made sense for PwC and an Orshot to be the manager of the retention funds.
Because I think in those cases the people, creditors were on notice, but they're on notice and nobody opposed. Yeah.
Yeah, and so if there's no opposition, it makes sense. In this case, there was no opposition, and our opposition was very specific. And our opposition was that because McVeigh had taken a position
early on
that this was not retention money, and as a consequence he had actually spent around $1 million of that retention fund, we made the argument that it was not appropriate for McVeigh in that situation.
Well, we thought there was a conflict, and I think the conflict also stemmed from the agreements that were made in the back end between Decmil Australia and McVeigh, so where they topped up the fund and they had some arrangements in terms of fees as well, where they would pay for a portion of his fees. So we thought that there was a conflict between, with McVeigh acting in that role, and the court eventually agreed that there was a conflict.
It was a very Decmil Australia agreed is that they would make sure that the retention fund was whole. And so regardless of what the level of retentions was, Decmil Australia would make that whole. And that makes sense because, well, they're a good corporate citizen, they want to do the right thing, they want to be compliant with New Zealand law, there are directors potentially that could have liability and they wanted to protect their directors. And again, I just think Decmil Australia is a good corporate citizen in that respect. So, but because there was an undertaking between McVeigh and Decmil Australia, there was another, Justice Duffy that talks about the perception of a conflict. Doesn't mean that anybody was acting badly, but the perception or a potential conflict was enough to give the judge in the situation some pause, but also the conduct of the liquidator by making the decision before McVeigh had got a decision from the court whether or not this was retention money or not, he proceeded to spend it.
Yes.
And as a consequence of that, that also influenced the judge's thinking.
I think the judge was critical about the fact that monies were depleted before there was a decision on that point. Because if it was found that there was retention money and it was at a certain level, then there would obviously be a shortfall. So I think the judge did pick up on that and was critical on that point.
Yep. So one question, Adam, from a legal perspective, does this create potentially precedents for a separation between the receiver or liquidator over the other entity and the retention fund receiver going forward?
It definitely does create a precedent to have them as separated roles, because this is the first time where you've had a liquidator of a company and a retention receiver that aren't the same person or from the same firm. So I think that there is a precedent. However, the fact there are quite unique circumstances here may make it, not as binding on future cases. So if you look at the Allshot and Corbell case, although that wasn't contested, obviously that had the same person was managing the retentions and the liquidator. So I don't think we have here a binding precedent that says that all future insolvencies you have to have them split. I think it does start the building blocks around independence and having that that full sort of lack of conflict. I think it starts moving in that direction. So whether it's I don't think it's a binding precedent, but I think it definitely is good step in the right direction.
So it means that if you are the receiver or liquidator over a construction company with retentions, you cannot be guaranteed that you will be managing the retention fund and that your conduct is going to influence the decision going forward, although this is perhaps a relatively limited precedent because the law has changed. And the construction changes coming through in the Construction Contracts Act potentially means that this will only apply in a relatively limited number of cases. But nonetheless, it's a really interesting case, and I agree. I think it's case specific, and I think the judge here was influenced in McVeigh's favour by the potential duplication of cost.
Yes.
I think the judge was nervous about the fact that there would be some duplication of work and some increases in costs. And so I think the default is in favour of the receiver or liquidator over the entity to be the person managing the retention fund. And it's the conduct of that individual that is potentially going to determine the outcome.
But that's really important, I think, just generally for creditor rights, because normally creditors are very passive. And liquidators and receivers, although they have a statutory obligation to have their interests accounted for, often the conduct matters in terms of how they make these decisions. So the decision first off to categorise these as general pool money and make that application maybe in hindsight was not the best move. So I think that we're having the more kind of precedent and instruction from the bench around what we should and shouldn't be doing is helpful. And I think putting the creditors at the forefront is always going to put you in good stead if you're having to go to court and make the argument, right? Your conduct matters, and I think that's important just for creditors' rights generally. That you can't disregard or do things that are obviously moving against your interest.
And so I think this was well argued by Mike Colson, ably assisted by Wynne Williams. It was an excellent result. We were very happy.
It was a joint effort, and I guess props to all of those that were involved in terms of the retention crew. And it's 38 pages, so it's a pretty long judgment, but we'll have the link to the judgment below, so you can check it out and you can read the relevant parts where Justice Duffy sort of, I guess, untangled all these issues and gave us the right result.
It's a very accessible judgment. So and it does talk about some of the previous cases as well. So it's excellent.
All right.
Thanks for watching.
Thanks.